Hello, have a pleasant stay. Today's class is internal reconstruction or alteration of capital. I'm Srimati from Dr. Ambedkar Global Law Institute, Tirupati. Let us see what is alteration of share capital. You know what is share capital, which has been given under the capital class of Memorandum of Association. But as per a layman knows that the capital should not be altered. When it has been given under the authorized or registered capital, it shouldn't be altered. But it can be done in different ways. That is alterations which do not require the approval of the court of law or alterations which require the prior approval of court of law. So here we are going to see the alterations which do not require the approval of the court of law. That means without approaching the court, the alterations can be done. So under the provisions of section 94 to 97 of Companies Act. So what is given in this act means, so this is about can alter the capital class of Memorandum of Association in 5 different ways. The first one is the company can increase the share capital by the issue of new shares, that is increasing the capital. The next one is consolidate all or a part of its existing shares, which is about a smaller denomination, into the shares of a larger amount. A small part can be converted into the large part. And subdivide all or part of the existing shares of higher denomination, that is having 100 rupees, can be changed to 10 rupees each, like that is into shares of lesser amount. And convert all or any part of his fully paid off shares into the stock. This stock is not raw material. It is about fully paid off shares converted into stock, and vice versa. Stocks can be converted into shares. And the next one is cancel the unissued share capital. A company can make any of the above 5 alterations if it is authorized by the Articles of Association to carry out such alterations. Or an ordinary resolution is passed in the general body meeting, then they can do it. So as per section 95 of Companies Act, these alterations must be notified to the registrar of companies. You know who is about registrar of companies, and the copy of the resolution should be filed with him within 30 days of the date of passing of such resolution. So the copy should be submitted to registrar of companies. So what is internal reconstruction or capital reduction is? So here this reconstruction refers to reorganizing the capital structure of the company. So here this can result in a reduction of claims of both the shareholders and creditors against the companies, that they will forgive some amount towards the company. Reconstruction may be necessary for those companies when their financial position is very bad, and this reconstruction may be external or internal. Let us see what is external reconstruction is. It's about a new company is formed to take over the business of an existing company which will be liquidated. So the company goes to liquidation and forms a new business. So what is internal reconstruction means? That is capital of a company is reorganized so as to enable to make a fresh beginning after eliminating certain accumulated losses. Say for example preliminary expenses or accumulated profit and losses, and then patent which has not been written off. All this should be eliminated and they will start with the new one. And the internal reconstruction is preferred by the companies over external reconstruction. Why means there is about a number of reasons. So the liquidation of the existing company and formation of new company always involving the large number of legal formalities, and also it takes expensive, it's more expensive. And accumulated losses of liquidating company cannot be set off against the profit of newly formed company. That is, the old company's accumulated losses cannot be set off against the new company. So the shareholders may lose certain important tax advantages because they cannot carry forward to the next year. So the time span needed for external reconstruction is generally for and more than that of internal reconstruction. It requires a lot of time. And the reduction of share capital under section 100 to 105 of Companies Act 1956. So it's reducing or completely extinguishing shareholders' liability for uncalled capital, or it can be refunding the surplus paid up capital which is found to be in excess of needs of the company. The excess capital is refunded to the shareholders, and cancelling or writing off the paid up capital which is lost or not represented by the asset. So these are the three ways in which the reduction of share capital can be done under section 100 to 105. The procedure for reducing a share capital is the first, the articles of company must permit it. That is, it should give a permission. Suppose if the article is silent, it may be altered through a special resolution to reduce the share capital. So, in general body meeting, the special resolution must be passed for reduction of share capital. And when it has been passed, it should be submitted to the court, and confirmation of the court for capital reduction must be obtained. And the company has to prepare for a specific scheme of capital reduction, and then the same should be applied to the court for an order of confirmation by submitting the scheme. And then the court may make an order confirming that the capital reduction on such a terms and conditions are as it thinks fit. So here usually the court ensures that the interest of the creditors and the minority shareholders are protected. And if any of them object the scheme, that is the minority shareholders or creditors objects the scheme proposed by the company, then the court ensures that the claim against them are satisfied. That is, it should be paid off according to the market value of shares or the values which has been set by the creditors. And the court may also ask the company to publish the reason for the reduction for information of general public. It should be published to the general public why the capital reduction has happened. Then the company may ask to add the words "and reduced" to its name for a period of time, though it is appropriate by the court. A copy of the resolution to reduce the capital and the court's order of confirmation should be filed with the registrar of joint stock companies. So this is the procedure for reducing the share capital when it is about joint stock companies. Hope you understood. Stay tuned. Until the next, it's bye from Srimati. Thank you.